Our next case this morning is Rayford versus American House, Roseville. This is also a 15-minute mini oral argument on the application. Good morning. You both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of your own time for that.
Okay, thank you.
You can begin when you're ready.
And good morning, and may it please the court. Carla Akins on behalf of Ms. Rayford, who is the appellant and plaintiff in this case. I was listening to the argument, so I'm going to cut right to the chase. The public policy involved here is that nobody can tell you what the agreement is. How did the employee actually agree to this? They signed their name. Did they understand it? Did the employer even bother to show that the employee understood it? No. They don't have any affidavits. They just show a document that they purport to be my client's signature and say she signed it, she understood it, she must have known what was going on. Well, that's not the case. And in this particular case, it's actually not applicable at all because the defendant already admitted in the first line of his statement of facts and its summary disposition motion that she was hired on February 14th. This document wasn't signed until February 20th. So what was the additional consideration? You have to have new consideration every time you have a contract. She was already hired without this. Then she works for 6 days, and then you give her this contract, and now she has to sign it. And what's the consideration for that? They didn't pay her anything. They didn't say that they paid her anything else. There was no new consideration. There was not an agreement. So that's a primary issue here. But the matter at hand, I think, and what's overarching in the arbitration and in the workers' comp area is that employees they don't have a choice here. And it doesn't matter how sophisticated you are. I really do appreciate and like the opinion in the Rodriguez case out of New Jersey because I think they did a very good job of explaining the public policy matters at issue. You could substitute LAD, which was their statute, with ELCRA and have the exact same argument. But they talk about sophistication, and I think that's the wrong place to start because I've spoken to attorneys who don't practice litigation, who don't litigate. And if I tell them arbitration, they have no idea what that means. If you've never done one, you don't know what arbitration means. You have no idea. You don't know what a statute of limitations is. They talked, I think, in the Rodriguez case about an HR person being sophisticated. But I would submit that the HR person didn't write this agreement. A lawyer did. And it's not that what we're doing is so sophisticated. It's that this is our area. We understand it. Other people who don't practice don't understand it. We don't dabble in medicine and expect, oh, well, you should know how to cut because we've all cut before. No, we don't do that. That's no different over here. We're talking about practicing law, and you're holding people to an agreement that was drafted by attorneys and thinking that they're going to turn down their job because their employer required them to arbitrate. They're not going to do that.
Oh, okay, along those lines, in your brief, you suggest that equal bargaining power is necessary to form a valid contract.
Yes, Your Honor.
What exactly do you mean by that?
That it's necessary, or what does equal bargaining power mean?
Well, I read your brief to say that equal bargaining power is necessary to form a contract.
Yes.
What do you mean by that?
It means that the parties have to be on equal accord. So if you're not an attorney who actually litigates, not just a corporate attorney. I was a corporate attorney. I didn't know anything about arbitration.
They've got to be equal footing.
Yes.
Wouldn't that invalidate most, if not all, contracts?
No, I don't.
Entered into?
No, I don't think so.
I go to buy a car, I'm not on equal footing with the dealer. I go to sell my home, the broker's telling me what the terms are. There's not a lot of equal footing in contracts. So I'm having a real hard time with this concept of equal bargaining power and the absence of it in validating contracts.
Okay, so in specific to employment, I think it's just a different question you're being asked. You could walk away from that sale if you didn't want to sign it. We all sign terms and conditions every day. And
walk away from a job if you don't like the terms of what they're asking you to do. People do it all the time.
I struggle, and I'm doing this while I've never heard of anybody walking away from an employment situation because their employer asked them to shorten the statute of limitations. They don't even know it exists. I've never had anybody. That's why we were filing these cases. I have the advantage of actually I practice this. That's what I did. I was in the trial court. I deal with people on a daily basis. They have no idea. They don't even know what their civil rights are. That's why they're coming to us. They don't know what they're giving up. They don't know that they're giving up constitutional rights. They don't, or potentially constitutional rights. They don't know anything about that. They don't care. They assume, just like the rest of us do when we sign contracts, that, oh, well, it must not be that bad. And then they come to us and we say, well, it's past 6 months, so too bad, even though that's not what the policy is in this state, that's just supposed to be 3 years.
And of course, is a distinction that civil rights are something that are guaranteed in our Constitution, whereas I guess buying a car is not.
Absolutely, Your Honor. And to your point, because I was already here on McMillan once, and Your Honor wrote the concurrence, which I agreed with. We need to go a step further and talk about this on a public policy basis, because in McMillan case, I argued the policy there, but Your Honors all agreed that it's at least a question of fact. So what does that mean? You have to establish the fact. So all of these cases should go back to the extent that that's not been established, that somebody actually did. To your point, Justice Zara, if that is what happened, then do a deposition, get a declaration, find somebody who's going to say they actually did agree, they actually did understand. Get that factual development before you go kicking a case when a person didn't understand. But I'm speaking to the practical side of it. Nobody understands that. They have no idea. They don't know what Elliott Larson is. They don't know what the Persons with Disabilities Civil Rights Act is. I have to tell them that. We have a 90-day statute of limitations when it comes to whistleblower, which I think is extremely short because most of the time most people don't come that fast. And most people don't come to me that way. I will say the vast majority of people come because somebody else told them, you know what, this doesn't look right. Either somebody who worked there, same thing happened to them eventually down the line later on, and they didn't want to say anything because they didn't want to lose their job. You're asking people you're putting something like not putting food on your family's table against, buying a car. That's not the same. They don't have a right to violate people's civil rights. That's not an employment action. They're not supposed to be doing that.
Counsel, is it your position that if we were to agree with you that it is against public policy that you can't contract any shorter than 3 years? Or is it that 6 months, maybe there is somewhere in between 6 months and 3 years where that's okay? Or is it just you can't, the legislature has, and the Constitution, the people of the state of Michigan have recognized this cause of action. They've given us 3 years, all of us 3 years to bring that claim, and we can't go shorter than that.
Well, I would point the court to Justice Kelly's opinion in Herwire, and I know that this was not my case, but just listening to the case before me, the issue with Camelot is that it was, to your point, Justice Welch, it was talking about insurance. And actually, it was actually a contractor who was doing work, and then they stopped getting paid. So you had two people who were in business. And Justice Kelly was very concerned and said that there are public policy implications here in this context that makes the shortening of the statute of limitations something we need to consider carefully in this context, in the context of Rodriguez, where they talk about unconscionability. Even if, let's say that they did agree, let's just say that they actually did agree. As Mr. Marco was saying earlier, there's certain things you just can't agree to. You can't agree to have your civil rights violated. I don't think we want anybody to be able to do that, or we would expect that I bet everybody would sign that and not understand what it was. No one's going to not take a job that, again, feeding their family with not having an arbitration against their employer, or not being able to go to court, or not being able to sue someone after the time period.
Well, and I agree that they couldn't, you can't say that you can waive the substantive right, like, you can't ever sue me if I discriminate against you. But is there a distinction that makes a difference with the fact that this is a procedural way in which to bring that claim? 6 months, 9 months, 12 months, whatever, and the legislature. So yes, you can't, as a matter of public policy, force somebody to or get them, contract away their right to protect themselves against discrimination. But can you shorten the time in which they have to actually come into court and bring that claim?
Well, again, I would direct the court to Herwire, where Justice Kelly specifically says that in this context, first we should have a certain statute of limitations. I believe that was argued earlier. We should know what the time limit's going to be, and it should not vary case by case, which is what the opinion in Herwire states. I don't think that we should be able to say whether, because we don't know in a particular case why it took 6 months, why it took a certain amount of time, are we going to go every single case to say, well, this person should have done this in this time, and this person should have done this in this time, and therefore this should apply? I don't think that you should allow the one who's doing the oppressing to set the time period to sue them for the oppression. I don't understand that, to allow them to select what the time period is when the time period's already been set by statute. And that's, I want to make sure I get that right. And Herwire specifically states that we should just, they actually did go along with the statute of limitations that's set forth in the RJA and not go into the business of trying to select which time was correct. And that was the issue with Timco, because Timco made it seem like Herwire was saying that 6 months was reasonable. They didn't get into reasonableness. They specifically said, we're not going to do that, and that there are all of these issues of unconscionability and the unequal bargaining power at issue, at play, that we can't do that. I just don't think that we want to get into the business of trying to figure out how long is too long, how short is too short. I can tell you that in Title VII context with the Logan versus MGM, Sixth Circuit has already said you can't shorten that. So, and they've said it in, I believe it was Tompkins versus Fresh Products. They said you can't shorten in the ADA and the ADEA context. I don't see why. And in both of those cases, they have a footnote about Michigan law. Michigan does allow it, and they cite Timco. And I said in my brief, I don't think that we should be a footnote any longer. That should not be the case. The whole point is to eradicate discrimination. And as
It seemed pretty important to the federal courts that the statute of limitations appeared in those statutes that you referenced themselves, which, when the opposite is true, when the statute of limitations is not in the actual statute, but it's in a more general place, they said that contractually shortened limitations period are acceptable. So if you're urging us to follow the federal case law, wouldn't your client lose?
Well, I think they're saying that because that's what we had been doing here, but we don't have to do that any longer. That means they were citing Timco. They were saying you can do that because
I'm talking about you referenced the federal cases, and the
Right.
federal analysis takes into account whether the statute of limitations is in the very statute giving rise to the cause of action. So, for example, in Title VII, Congress created Title VII to be self-contained. That is, the applicable limitation period resides within Title VII itself. That seems to be a dispositive factor in the federal court's analysis.
I would just argue.
If we followed that analysis, your client would lose, I believe. So I'm asking you, if you're asking us to adopt the federal analysis, wouldn't that be detrimental to your client's position?
No, and I don't think that they weren't commenting on Michigan law. I just want to be very clear. I do understand that their distinction is made. It gave them a reason or a basis to be able to say follow that. But we have other reasons and other bases to say don't do that. That's 3 years is what we've been following. That's what we do. That's what we tell our clients. I don't even know about this until we come into the court, and then here they come with a document. Millen case, she had asked for her employment file 3 times, 3 times, and never got the document until we get in here, and here comes a summary disposition motion. The problem is I don't think it's dispositive of the issue because you're still dealing with the unconscionability factor, which is that the reason that we don't do it isn't just because it's not in there. We don't do it because it's not right, because people don't know, because they don't voluntarily agree, and because it's unconscionable to have civil rights cases shrouded in darkness. I don't think that it does a disservice to all of us, because what happens, these people end up going on unemployment, they get fired, they get terminated, they have all these things. We might win the unemployment case. I handle those too. We might win the unemployment case and still have to deal with the civil rights part of it, and that's a whole different issue.
And we also don't do it, though, am I right? And because the legislature said you get 3 years to bring that claim.
I'm sorry, I didn't hear the first part.
Isn't it also because of the legislative statement that you get 3 years to bring this claim?
Even if it's just the default statute.
Right. I mean that's a reason why we recognize the importance of civil rights, of giving a cause of action, of protecting that, and it's not in the statute. Maybe it didn't need to be because the RJA, there is a statute that covers all the statute of limitations, and that the legislature was satisfied that 3 years, like so many other causes of action, is what the legislature determined to be the balance and the right fit in this case, right? They could have, like you mentioned, whistleblowers, they could have said 90 days. I mean, the legislature has chosen what they've chosen, and they chose 3 years. And we would need some reason to come off of that.
I would definitely think that, and I apologize, my time is running up because I did want to have time for rebut. If I can just answer.
You won't have any time to rebut, you might as well finish.
Say one more time?
You're out of time, so you might as well finish answering the question. There's no rebuttal time, really. So go ahead, and then I've got a question for you.
Okay. Yes, because I mean, certainly with respect to the common law, that's what's been done. They've recognized it's 3 years, and that's what's repeated over and over again in many cases, that's what's been done. And if we're going to shorten that, I think there needs to be a good reason to do it, and also an equal and fair reason to do it. And I don't believe that should be put into the hands of the entity who is the one being sued.
As you've litigated this case, you focused on unconscionability, which you've raised again here. Have you focused at any point, have you preserved the public policy argument that Justice Kavanaugh just laid out that we're discussing?
Did I argue it below, is that what you're asking?
Yeah.
I don't think we got into it at this level. At the time that we were briefing this, I think McMillan had been accepted, and so I had started to mention, I believe in the motion for reconsideration, I want to say, but don't quote me, I apologize if I had brought this, but I do know that your honors have the ability to, if you, obviously like you did here, and in McMillan, I believe as well, have the ability to address it if you feel like it needs to be addressed. Thank you.
Are you asking us to overrule or modify Soaring Pine or Terry v. Zwitt as to how we find what Michigan public policy is?
No, I actually think that you can use the reasoning in Soaring Pine to come up with the same conclusion here.
Okay, in your brief, you don't provide a whole lot of Michigan reasoning. You cite to Rodriguez and the New Jersey court, and you actually say there's no doubt that contractual limitation clauses which restrict civil rights claims violate public policy. How do we square then all the other out-of-state, other state case law that permits shortened limitation periods even in civil rights claims? They say that it's not a violation of public policy.
Well, if we stick with Michigan, I think you have Herwire, and I think Justice Kelly.
But Herwire's a dissent right now.
I'm sorry.
Go ahead, finish.
I'm
sorry. I'm sorry.
No, I'm sorry. In there, they don't, I think Justice Kelly didn't, there's what we maybe call dicta, but obviously the Supreme Court knows when it speaks, this may be used later on. And I think there's many places where Justice Kelly made clear, be careful here. This isn't the area to be doing that. This isn't like Camelot. This is a special situation in which you don't have the same bargaining power, Your Honor, that you have in those other contexts. I don't know what the other case. The reason I focused on Rodriguez is because the order asked me to do so. So I wanted to just make sure that I did that. But also, I think I don't know who wrote it. I'm sure they all collaborated. I was a law clerk, but I think it beautifully lays out exactly what the problem is and exactly why you cannot allow this in this context. You have the Michigan Department of Civil Rights whose actual duty is to investigate these things. And I may file with the EEOC more often, but a lot of people go to the MDCR. That's what they know. That's where they go. And so when I come to me, they've already gone to the MDCR, so Michigan Department of Civil Rights.
Okay.
So in that context, I don't know what other states are doing. I do know that New York City has outlawed non-competes as of this summer. I know that arbitration in sexual assault cases is an outlaw.
You've done a good job of answering the question.
Okay.
Thank you.
Counsel, I actually this is, I know what you do for a living. I'm just
Yes.
curious. Again, I asked your prior counsel in the prior case about this, sort of the impact, what you've seen in your practice. Do people come to you, and they obviously were here today, and you were here before us in McMillan, so I'm just sort of curious about sort of the argument that people's ability to put their rights forward have been hampered.
Oh, all the time. The amount of people who, there's plenty of times where I say, okay, even the 300 days. I just had a 300-day case the other day where I'm talking to a lady the very first time, and she says, I I said, well, what was the date? We go back and look, it's today. Today's the 300th day. Guess we got to get that
Very
charge
good
in.
timing for you.
Yeah, that's happened
Yes.
2 times in my career, but it's happened. And people pass the 6-month all the time. And I asked them, I said, well, why did you take so long? And most of the time, as Brother Counsel was saying, people, we have to figure it out. We have to give the Department of Civil Rights or the EEOC time to figure it out. And we should not be racing to court to try to hurry it up, because what happens is during the pandemic, the EEOC wasn't even issuing right to sue letters. So we had a situation where people were past their 3 years. So I had to hurry up, go file the state civil rights claim before the 3 years expired while the EEOC still hadn't finished their investigation. You know, some of those things have sped up, but I mean, everybody, the people who were caught in that gap are here now. And so it's just not reasonable to expect that people know right away or call you right away. Some people do, some people don't. Most people are scared of court. Most people don't come to court. The employer comes to court way more than I see the same defendant. And I just want one point. There is one defendant in particular I've had where the EEOC actually found discrimination against them, and they have an arbitration clause. And so nobody's going to get to hear that. That's why you don't do that here. That's why you don't have those things here, because this needs to be out in the open, and they need to be given the amount of time that they've been statutorily allotted, that the courts have upheld as allotted in every situation, not just for a particular person.
Thank you.
Thank you.
Morning, Madam Chief Justice, and may it please the court, William Thomas on behalf of the appellee, American House Roseville, LLC. A lot of the arguments that I've heard in the last few cases and from Sister Counsel this morning and talk about what is just, what is right, what is best, that employees don't have a choice when it comes to what documents they sign at the time that they're hired. And one particular aspect of those thread of arguments brings up something that this court said in Tyrion that really runs contrary to the plaintiff's argument in this case. And this court said that making social policy is a job for the legislature, not the courts. This is especially true when the determination of resolution requires placing a premium on one societal interest over or at the expense of another. And that's what plaintiff's argument in large part was today, is that we should place the benefit or give, the rights, alleged rights of employees over contractual rights of employers. And so what this court went on to say is the responsibility in drawing lines in a society as complex as ours and identifying priorities and weighing the relevant considerations between the competing alternatives is the job of the legislature. And when it comes to public policy specifically, the objective sources that this court says that have to be looked at, these objective legal sources, this court's job is to determine what the public policy is, not what it ought to be. And that's plaintiff's argument here, is asking this court to enforce a policy that simply does not exist. Okay, and to basically judicially legislate and invent a policy that doesn't exist. Now, Justice Kavanaugh, you've asked every counsel on these issues here today, how do we frame this issue? And you have to look at it, it's almost like a three-dimensional chess here, because on the one hand, at its lowest ebb, we're talking about the policy of the party's freedom to contract, a bedrock principle under American law. You also have the policies that underline the statute of limitations in general that this court has spoken about in the Lammerman case going back to 1995, and all those policies of why the limitations period exists. And all of those to encourage the prompt recovery of damages, to penalize plaintiffs who have not diligently pursued their claims, affording security against stale claims, making sure to protect against the fraudulent assertion of claims, and to also remedy the inconvenience or delay against stale claims being asserted. All those policy interests certainly favor employers. These aren't rights given to employees. These policy considerations favor the expedited adjudication of claims. And then specifically in the area of the Civil Rights Act, I think it's, again, how it's viewed. We're not talking about curtailing substantive rights here. Again, Justice Kavanaugh discussed that the limitations period is a procedural device. This is not a substantive right that is guaranteed under the Civil Rights Act. The Civil Rights Act is silent in this regard. There's nothing in the Civil Rights Act that speaks about the limitations period. And that's important for a few important reasons. Number one is when the Civil Rights Act was enacted, the legislature repealed the Fair Employment Practices Act, which did contain a statute of limitations for bringing claims there, albeit administrative claims. But still, it was removed and replaced with nothing. Second, the legislature has spoken in other employment contexts, whether it's the Whistleblower Protection Act or the Public Employee Relations Act, where they've specifically embedded a limitations period within the statute. And the fact that I believe one of the prior counsel made mention of is that the legislature has specifically spoken in certain circumstances, albeit life insurance, that the limitations period for those claims cannot be contractually modified. The legislature has occupied the field on this issue. And if the legislature is so inclined, whether it be in the workers' comp area or the civil rights area, if they believe it is the prerogative or the policy of the state that the limitations period for those claims cannot be abridged or modified in any way, then it is the legislature's duty to do that. And it's
So they're saying that you have 3 years to bring a claim is just, that's our best guess, but go ahead and do something different. I mean, you're saying they've occupied the field, and the fact that they've shortened it in the context of life insurance policies is this definitive statement, and they haven't said it otherwise. Why, I mean, they have said what the statute of limitations is very specifically in the RJA for, you know, for any number of claim, contract claim, malpractice, false imprisonment is different from your general 3 years. Why is that not a statement, particular of public policy, to support the public policy of recognizing the right to protect civil rights and allow somebody the right to bring a claim?
a few reasons why it isn't. First of all, in her wire, this court did say that statute of limitations is what the legislature believes to be the reasonable maximum period of time in which to bring a claim. It's the ceiling, it's not the floor. That's the first thing. The second thing is that the RJA does specify 12 times in 5805 what the limitations period are for certain claims. Civil Rights Act claims aren't mentioned at all. They fall into the general residual statute along the lines of a negligence claim or a nuisance claim. So the legislature didn't specify any specific policy with respect to
So
civil
would your
rights.
position be that anybody is free to contractually shorten any of those 12 statute limitations in the RJA?
I believe that the common law at the baseline is that parties have the utmost freedom to contract, and the legislature has every right to abrogate the common law, as this court has said a number of times.
Could it be, you have 30 days?
I can't speak on what specific time frame, but the one point that I default to is that the legislature has said in the Whistleblower Protection Act context that 90 days is sufficient. So that's the number that I can look to the legislature and say, you have held public debate on this, you've looked at the pros and cons, and you've heard from everybody, and we've decided that 90 days to bring a retaliation claim is sufficient. So to that bare minimum, I would say that that passes muster, at least from the legislative point of view of things. And so the fact that the Civil Rights Act is silent on this issue, there is something else that prior counsel did mention that we also briefed as well, is that it's not as if the legislature is sitting on its hands with respect to the Civil Rights Act in this state. The Civil Rights Act has been amended numerous times in the 18 or 20 plus years since Timika and Clark have been decided, including twice this year. The legislature has decided just this year in two circumstances that based off of societal advancements or changes in our society, we need to update our statute to protect certain rights in certain contexts. If the legislature believed that the limitations period should not be shortened under any circumstance because of bargaining power or whatever reason they may see fit, they would act on it. And they could act on it tomorrow if they wanted to, but that's their responsibility to do. And it is not the responsibility of the courts to create the policy where no such policy exists. And on the contrary, and I believe Justice Zara asked prior counsel in the Monroe case, well, what are the sources that favor the other side? Certainly, if we were to get down to very specifics, certainly there's 100+ years of case law from this court enforcing shortened limitations periods. But if we look at it in the context of merely contractual, the right to contract, the freedom to contract, it's certainly protected under the Constitution, both the federal and the Michigan Constitution. Certainly the case law of this court has spoken at length about the freedom to contract being an ineradicable part of the legal fabric of our
But
society.
what do you do? Your counsel in the prior case said, well, yeah, but that's just case law. That's not a good expression of public policy. And I guess it's somewhat frustrating to me because I think it's like this, it's either or, it's contract or the freedom to contract or the policy of the state to recognize civil rights. And I think it's, why is it not that these, as you mentioned, they're the three, right? The right to contract, the policy behind setting statute of limitations, all of the things of what that means and what you're guarding against, and the constitutional and statutory right to recognize the protection of civil rights. And it's weighing those things, right? As opposed to saying, and I've heard, and I think your prior counsel said the same sort of thing. It's like, if you agree with plaintiff, it's just a couple judges, going out on their own whim and thinking this isn't right. But we would be, if plaintiff's position is correct, it's because it's in the Constitution and in a statute, and we are in fact respecting what the legislature has said to find that. Like, why are we not recognizing, it's sort of like, why can't we walk and chew gum at the same time? We can have multiple public policies in this state, and we're trying to weigh that. And why is it that the contract and your statute of limitations public policy should outweigh the recognized public policy of protecting civil rights?
So, and I think it's the way that it's looked at, Justice Kavanaugh, because what you talked about is that, yes, civil rights are protected under our Constitution and our statute, but we're not talking about civil rights, okay? The shortening the limitations period to bring a claim doesn't affect any substantive civil right that any employee or person has in the state. All it does is say in which time can you bring that.
You don't think, you can't fathom that having 6 months to figure out that you have a claim, find an attorney, bring a claim sufficient to survive C8 is different within 6 months as opposed to 3 years? The
we're
time
here
in which
today.
to bring the claim.
We're here today because obviously.
And what I can say is that I think we could poll every person in this room and they would have an opinion about they could give all types of situations in which, yes, 6 months is sufficient, or yes, 90 days is sufficient, or as counsel said, no, I've needed the entirety of the 3 years.
But isn't that why the legislature said, hey, we're not going to poll everybody, we're going to say you get 3 years?
And I would just go back and say that the legislature didn't say that for civil rights claims. They just said it for any claim that we didn't specifically talk about in 5805. And so
okay.
And I think when we're talking about in the employment context, it differs from negligence or medical malpractice. It's a different breed. There's different items that can be socio and economic to impact either the employers or the employees and the greater business impact. These are all great topics of debate, and I'm sure there is a host of evidence out there, pro and con American House's position or the plaintiff's position. And the place for that to be debated and to be decided is in the legislature, where they've already said, and they've already looked at it in one context and said, there are certain times where we cannot prohibit, or where we can prohibit the limitations period from being modified. And they haven't done it in any other context. And it's the position that if the legislature felt it was necessary, they'd act on it. And they're not sitting on their hands.
So you sort of read the RJA as the legislature saying, hey, here's what we think is reasonable, but feel free to come up with something different.
I see the RJA is merely providing the basic procedural devices to this, but I think that the fact that the legislature didn't speak to Civil Rights Act claims in general does speak volumes as to the fact that it didn't come up in their when they're drafting this, or any time that they've amended it since, that we need to specifically mention Civil Rights Act claims, because, and it just shows that there's nothing, at least in the legislature's mind, there's nothing uniquely special about a Civil Rights Act claim versus, say, a negligence claim or a nuisance claim. And a couple of the questions that the justices asked, just to ask Sister Counsel, I did want to address. Justice Viviano, you asked the question that if the court were to adopt the federal analysis, would plaintiff lose? And the answer is yes, they would, because the federal analysis was based off of the existence of the limitations period being a substantive right and actually embedded in the statute, which is not the case here. And actually, the Logan versus MGM case that plaintiff cites, they go on to say that federal courts, if it's not written into the statute, they enforce shortened contractual limitations clauses. And Justice Welch, I know you've asked multiple parties on the plaintiff's side, what have you seen in your practice in terms of different situations, maybe going to different attorneys and the clock running out if you have a shortened time? On the other side, one of the biggest policy deductions that I take from the limitations period in general is the preservation or the exclusion of stale claims, because one of the biggest problems on our side of the V, so to speak, is when you have a claim that comes about 2 years after the fact. Memories fade, evidence gets misplaced, evidence gets lost. Shorten the limitations period to 6 months, for example, is not only to the benefit of employers, but it's to the benefit of employees. You're asserting that your rights have been violated in some regard. The way to get the best evidence and the resolution of the truth of the facts, the sooner it can be brought, the better. Because it's a habit, it's a practice, and it happens in cases I see all the time, where we get, someone says that they were harassed or that they were retaliated against, and you speak to people. People change jobs and move on, and you can't find them. People can't remember what happened in a conversation that happened 2 years ago. We don't know where we put that file, and those emails have been archived, and we can't find them now. So there are balancing interests on the other side to shortening the limitations period and the virtue of doing so. And last point.
Your time is up.
Yep, and I will save the last point. It's already been briefed enough. Unless there are any further questions, greatly appreciate it.
Okay, thank you very much.
Thank
The
you.
case will be submitted.